This week we will talk about the case Henwood and CIR. This case happened in 1995. This is the leading case concerning the tax treatment of restraints of trade and lead to a law change. So, what happened in the case factually? The taxpayer, Mr. Henwood, entered into a contract with an advertising agency to appear in 2 television commercials to promote Griffin's chocolate biscuits, for which he received a total of $42,500. The contract included a restraint of trade clause restricting him from being associated with the promotion in New Zealand of any product or brand which was in any way similar or competitive with the biscuit or confection products of Griffin Limited for a period of 2 years. This contract did not specify a particular sum pertaining to the restraint. So, the commissioner asked Henwood to pay tax for this amount of money, but Mr. Henwood argued that only $5,000 paid for acting service and the remainder being paid for restraint of trade. There are 2 legal issues in this case: whether the amount received by the appellant were partly capital in nature. So, if so, whether an apportionment of the amounts is to be made. The Court of Appeal held that the restrictive covenant was a capital amount because it has a significant effect on taxpayers' future professional activities. The court went on to apportion the payment received between the taxable amount for acting services and the non-taxable amount that for the restrictive covenant, with $37,500, equivalent to 88% of the total payment, be allocated to the restrictive covenant. Was the decision correct? And my comments. As a result of the approach adopted by the courts, the restrictive covenant payment will not be imposed. There were concerns that such payment could be made to an employee or independent contractor in substitution for salary or wages, and not be subject to tax. So, in Judge's eyes, as an actor, Mr. Henwood, so be perform services to somebody is kind of important capital of him. If someone wants to make him to stop to professional certain service to other people, so it's kind of like buying capital from him. So the money of transforming of capital On the other hand, this could be effectively to avoid tax for someone. So maybe the decision made by court was not reasonable. In my opinion, payments for restricting someone to perform certain services cannot be kept to nature. Over, over the years, a number of tests have been developed by the courts to assist in distinguishing between income and capital receipts. The most famous one between of them should be the principle that is income is the fruit or produce, not the tree. This principle developed in Isner and McComber case in 1990. Um, Income was seen as a fruit or produce. For example, dividends, rents, derived from an enduring source such as land or taxpayers' ability to earn income from personal exertion. Though the covenant was a significant intrusion on the future exercise of the parent's profession and the real restraint on his income earning capacity, which is taxpayers' capital. However, the advertising agency and the grievance did not buy his capital actually. Actually, nobody can buy someone's talent or knowledge indeed. They only restrict Henwood to use his capital in some way, which should be counted as renting rather than purchasing. Meanwhile, the amount Henwood derived from the restrictive commitment should be accounted as prepayment of service fee that he may lose in next 2 years by doing that for Griffin. So the amount is Henwood's income, no doubt. What had happened to their case subsequently? Since the approach adopted by the court may lead to tax avoidance. So Section C9 and GB30 were enacted. Those provisions could apply to payments that derived on or after 27th March 2001. Section C9 provides when a person is required to restrict his or her ability to perform services as an employee or independent contractor, so the money that he or she derived for this undertaking is income of this person. Therefore, he or she needs